One question we get often is with the legalization of specific hemp products, is the smell of marijuana going to be enough for an officer to have probable cause to search a vehicle?
Unfortunately, ever since the Farm Bill passed, making Delta 8, Delta 10, all those hemp products legal, the answer has been yes for the past 5 or 6 years. Up until August of 2024, so just about a month and a half ago, the law changed by a Tennessee Supreme Court case where they determined that a dog cannot tell the difference in smell when doing a dog sniff of a hemp product versus marijuana. And so that's where it becomes incredibly important to have a defense attorney who can argue for you to make the same correlation to a police officer, because a police officer, just like a dog, cannot tell the difference by smell or by looking at the actual bud itself, the marijuana, whether or not it is the legal version or the illegal version. And so, without being able to tell the difference by smell and looking at it, I think the State v. Green case that just came out can or should be extended to police officers. And the critical change that case made is it used to be per se. If you smell marijuana, an officer can then search the vehicle. The State v. Green case specifically changed it to totality of the circumstances, if you want to talk about what totality of the circumstances means.
Absolutely. So when we're looking at per se, we're talking about something that alone is enough for the officer to search the vehicle. So if a K9 had alerted on a vehicle and the allegation was because it was based on marijuana, that alone would be enough initially to search the vehicle. It's changed now to the totality of circumstances. And so what we are looking at is the entire investigation. It's no longer where the odor of marijuana alone for the K9 sniff is going to provide that probable cause. The question now becomes, what other potential indicators does the officer, the trooper, the law enforcement officer get when he is interacting with that person, he's observing that car? Are there other circumstances that he is able to reasonably articulate to where he can then say in court that he had the probable cause to search the vehicle?
Yes, absolutely. And part of the issue in the State v. Green case that doesn't help as much for the defense side is that, well, totality of the circumstances could mean the smell of marijuana plus nervous behavior. What individual pulled over by a police officer is not nervous, even if they don't have marijuana in the vehicle? Just being pulled over for speeding is nerve-wracking in and of itself. And so that's, again, where having a skilled defense attorney who can cross-examine the officer about the circumstances of the totality of the circumstances becomes so critical.
Absolutely. And it's not just so much focusing on, the little point where they're alleging that they get that odor. It becomes about, just like the case law says, the totality. So the entire investigation from beginning to end. It could be statements that the officer makes to other officers. So it's important to also have that defense attorney who is going in depth, getting into the details of your case to be able to articulate, to be able to litigate against the officer having that probable cause.
Definitely.